Welcome to Access and Privacy Online, the podcast where we delve into the latest issues, challenges, and advancements in access to information and privacy rights. I'm your host, Patrick Farnsworth, and with the end of the year fast approaching, we're holding year-in review meetings with major contributors. Today, we're thrilled to have FIPPA researcher Ryan Rutley and Executive Director Jason Waiwata joining me to talk about this year's activities. Let's dive in.
So thanks for having me back, Patrick. I'm really glad to be able to come back at the end of the year and take a look at what FIPPA has been doing. And I think a really important element that was new for us here at FIPPA was we've had Ryan for 2 years as a law co-op student from the University of Victoria in FIPPA's architecture and doing research for us. And so that granted us a whole range of new opportunities there to build off of prior research, expand on existing research, and deliver some new material. So, when we look at that, Ryan, what did you work on last year? What did you work on this year? And how did that expand?
Yeah, thanks, Jason. And thanks again for having me back for a second term. Usually the life of a co-op is you get to know something and you start working on it and then hand it off and never hear what comes out of it. So it's been really interesting and frustrating in productive ways to see the developments in some of the things that I've been working on. My last term, I spent a lot of time on political privacy topics, particularly related to the federal political parties and how they are and are not covered by privacy and access law. There's been quite a bit of development in that I'm looking forward to touching on a bit later. But the one thing that's been very interesting is that last term I worked on the leading and trailing language documents, which are sort of the overall general survey comparative look at various privacy and access regimes throughout Canada. And I worked on that a little bit last term, but it wasn't my bread and butter. So it's been interesting to work on the offshoots of that work, which are in-depth documents on third-party exclusion clauses and vexatious and frivolous request clauses.
Yeah, and that's the thing that's been really exciting for me, because we've talked about the ability to do a deeper dive on that legislation on a clause-by-clause basis, particularly around exemptions, right? And so that's been on our radar and our list of to-dos for a while. And we've had theoretical concepts around those, how we would structure that, what's the methodology we need to employ, what are the questions we want to raise, that sort of dynamic. So we had our first ability to do that with you this fall. So let's start with third-party interests. Like, what did you do?
So the main difference between the general survey and the deep dives to me is that when we're looking at the leading trailing language, we're really just looking at just that, the language. We're looking at what is written into the legislation, and how that lives in the real world can often be very different from how it looks on the page. And that's something that I've really encountered in these two projects. Like, the third-party exclusion clauses relate to if a public body holds third-party information, there is an application for a request for information that includes that third-party information. There are mandatory exclusions that prevent the public body from releasing that information if it meets certain criteria. Now, what those criteria are changes province by province to some degree, but broadly speaking, every single province has a mandatory exclusion for third-party information that must or may result in certain economic harms to that third party. So if I'm just looking at the language, as in the leading and trailing language documents, that's relatively straightforward. I look at what each legislation includes and does not include, what it requires before the exclusion is triggered. Looking at it from a more real-world perspective, we start to look at how are the regulators interpreting that language? How have the courts weighed in on that? What are the outcomes for access to information that come from that? I very much had the experience of law being a fractal, where the closer you look at any particular detail, the more detail there is behind it. So I had to be judicious in how deep I would go into, for example, various regulator decisions, and how deep I would go into the variation and keep it at what differences do we see from regime to regime. So go ahead, Jason.
Well, and I think what shocked me when I was taking a look at some of the research that you've pulled in and taking a look at the clause is how much this varies by postal code, if you will, right? Like that variation. I think there's this perception amongst researchers in some respects that access to information and privacy are rights across Canada and they are exercised in an equitable way. And yet when you dive in and look at the interpretation on these clauses and their application, you see that every province has some pretty substantial variations in how these are implied and interpreted. Third party is one aspect. We also see that in the frivolous and vexatious side too.
Yes, and there's sort of an interesting two-way flow of interpretation going on in both cases. So in vexatious and frivolous clauses, every province and every jurisdiction, so that includes the feds and the territories, has some kind of exclusion permitting a public body to disregard a vexatious application, except for Yukon and Quebec. Those are the only two that I couldn't find that had that sort of exclusion permitted in the language of the legislation. In some provinces, the public body has the right to exercise that discretion on their own. If they themselves determine that a certain application is vexatious, they're permitted to make that determination, subject to the usual notification and appeal type clauses. In most provinces, BC included, the public body is required to make an application to the regulator. The regulator looks at the situation and makes a determination as to whether the public body is permitted to disregard it. So we see that difference in process, but then we also see quite a big variation on what circumstances are included under those clauses. We call it vexatious, but that could also include, that doesn't mean to say that it has to be bad faith. In some provinces, having an unreasonable interference with the operations of the public body is enough to grant that exclusion. In some provinces, it also has to be, that can only be applied if it's systematic or overly broad. There's a laundry list of various terms or various circumstances that could apply in each different jurisdiction. Now, that said, each one differs, but they tend to crib from each other's homework when it comes to interpretation. So even if a province doesn't permit disregarding a request that would be unreasonably burdensome on the public body to respond to, that might kind of go into whether it's considered vexatious. So the provinces will read these various ways that it could be disregarded in relation to the terms that are in their home legislation.
So when we look at that in terms of lower court rulings, upper court rulings, what is setting precedent, those types of things, what I noticed as well in the research, you spent a ton of time diving into the definitions, as you've sort of alluded to with this, because those are really significant in this regard. What are you seeing as a UVic law student looking at this and diving into the law? What's your takeaway from doing this type of research as you're considering these things?
Well, it's the old saw in law. It's, the answer to every question is it depends. And this has really, really driven it home that definitions aren't as clean cut as we as lay people looking at the law have this feeling that words have certain meanings within the law and that you should be able to kind of expect that has a consistent meaning. And this has really demonstrated to me how contingent and particular each definition is. The definition applies for this purpose, in this circumstance, in this legislation, which makes it very difficult for us to be able to compile them in a way that's useful for public legal education. It makes it very difficult to say with any kind of confidence, this is what this term means. Now, we can look at, this is sort of the range of circumstances it tends to cover, but it really drives home the barrier that there is between statutory interpretation within the legal sphere and the ability to communicate that in a way that's useful to the public.
So how do we manage to do that? One of our goals at FIPPA is the podcast we're running with Patrick and sort of our ability to educate the public and bring them up to speed on these things. How do we take this language that's not plain and make it plain so that people can understand what their rights are?
So I think looking at this is where it becomes useful to look at the case law, and it becomes useful to see the types of things that regulators are expecting from the public bodies as far as how they're justifying an exclusion. And it really, to me, it comes back to, we need more transparency and reporting about how these are being used in the real world. That would really, really help our ability to understand what is actually happening within public bodies, what circumstances are actually applying third-party exclusions or vexatious exclusions in a way that goes beyond the impressionistic. So I wish I had a much more clear and satisfying answer to that. This is something that I've been struggling with all term, and I'm happy to run at it from another direction if I could be more helpful.
No, but I think one of the things that really struck me when I was considering these, and this was foundational research that informed another activity we did in November, but this whole dynamic of third parties and how that plays and intersects public interest overrides, and whether or not those third parties' interests trump public interest, and what are the mechanisms embedded in the legislation that allow the public interest to override those third-party interests in the release of information, and how we would expect public bodies to be weighing the public interest over the private interests of a third party. And that was really important, I think, in that particular research, in the same way that when you talk about reporting, that we saw massive gaps and black holes in reporting in terms of who is qualified as vexatious and frivolous in different provinces, where some provinces are reporting on an annual basis because they are having to make those requests to independent third-party regulators like a commissioner, and other provinces where that decision-making ability is delegated to the head of a public body, and there's no application required. You have no idea how many people are actually being qualified as vexatious and frivolous in that respective province, which means there could be a massive application or over application of the qualification without any consideration or due process in that respect.
Yeah, and so that sort of places us in the circumstance of reading from inference in the various annual reports. I found an example for the vexatious and frivolous clauses that Saskatchewan is an application regime, which is to say that public bodies have to apply to the commissioner to get permission to disregard an application. They reported 3 requests. If memory serves, they did not report how many were granted, but there were 3 examples. Their neighbor province in Manitoba, similar population, they do not require application to the ombuds. It's rather than a commissioner in Manitoba. Public bodies are permitted to apply that at their own discretion. And from what I can tell from the statistics, it's not reported explicitly, but doing some inference, probably about 30 applications were disregarded as vexatious or frivolous in Manitoba at the same time. So if that's anywhere near correct, we can say we have, at least in this example, about 10 times the application in Manitoba that you do in Saskatchewan. And if somebody wants to challenge that decision, they are then in the position of having to challenge it to the ombuds. In Manitoba, fairly limited what powers they have, or take it to court.
Yeah, so that really, and this speaks to that presentation then, and we had the unique opportunity to take you to the Canadian Bar Association Access and Privacy Conference in November. We were sort of presenting at 2 tables there. I was part of the frivolous and vexatious panel. You were part of the third-party exemption panel. What's your takeaway from that conference? I mean, going there as a law student and they're flying the flag for FIPPA.
Well, it was great fun on the purely personal level. It was very interesting to see a relatively small and tight-knit crowd at the conference. I definitely had the feeling that I was showing up to a party where everybody knew each other, and honestly, I felt very much welcomed into that. Like, I inadvertently had breakfast with a commissioner and partner in a privacy law firm. And everyone was happy that I was there as a student, that I was even interested in the area of law. So on the personal side, that was great. I also think FIPPA was able to really build on the credibility that we've established over the years. they took care of us at the conference, so we were able to show up in force. And the thing that stood out for me is that at that time I was about 6 weeks living and breathing these clauses, and that through our legal research program here with the supervision and the training that goes into it, I was able to have a pretty high level understanding of these clauses and how they operate between the different provinces, that I was able to have an intelligent conversation about it with. There was someone from a public body and someone from a commissioner's office who was administering these clauses. So now, of course, I could only really speak intelligently about those clauses, but the type of research that we're able to do at FIPPA is bringing us to the same kind of conclusions that people in the ground are observing, and the things we're frustrated about are consistent with the things other people are frustrated about. So I felt like that really drove home that the process that as a co-op student FIPPA has for giving me the tools that I need to do this kind of research were very effective, and also that our presence there was effective in pushing the conversation toward a rights-based perspective of access and privacy.
What I was really appreciative of as part of that process was how, when we were preparing both the written material here and for the presentation, we've been drawing from Spencer Eisen's research as part of this as well in that access assessment study, and sort of how those inherent assumptions of access to information and information management within public bodies is suspect in a modern context, and how all of this legislation, all of these interpretations are predicated on that dynamic of having a consistent application of the law and interpretation. And yet when you get into that, there's massive variation, this vibes-based approach that we've talked about in other areas that keeps coming in here, which again, as I look at this, and we see that erosion in public trust in public institutions, you can understand that, because we see this inconsistency, and the instant you push back, the instant you say, well, have you applied that exclusion properly, the public body backs away from that application of the exclusion. Or are you sure that's an accurate calculation of the fee, and they back away from that right away. And something
that came up, so, sorry to cut in, but something that came up from people within public bodies or their council, a theme that came up in those conferences is we document the exclusions that we're applying. We do not document the exclusions that we considered and didn't apply. And part of that, can read as a bit self-serving. It's like, hey, we didn't exclude it for this reason. But it does kind of address a failure of documentation and a failure of providing reasons for the decisions that you make. You can also see situations where there's no documentation of why they did apply a certain exclusion.
So when we look at this and consider where we're going to go with this down the road, what do you have to say to law students coming in after you?
You'll have plenty of interesting work to do. I could probably brainstorm a handful of different directions that this research could go into. One thing that struck me sitting in the conference in a breakout session, that not something that attracted my interest, but they were talking about the complexities of complying with the privacy legislation of various jurisdictions. And it struck me that the work that they are doing is exactly the work that I'm doing here in making a big spreadsheet of every clause and tracking who has this requirement, who has that requirement. So any prospective co-op students, you are going to get the experience of doing a deep dive into something you've never looked at before and coming out with a set of knowledge and tools for doing that in other areas.
Now, I know you're not a conspiracy theorist, but you do lean a little bit center left, perhaps. I'm not quite sure. I don't want to out anyone in this regard.
You definitely got the right direction.
Okay.
I would say that I'm definitely come from a civil libertarian perspective. Not that defines the entirety, but that is a perspective I come from.
So when we think about that as it intersects privacy and access to information, what are your takeaways in that regard? Because this isn't necessarily an area of law that people do a deep dive into in second or third year law. But now you've been at FIPPA for 2 co-ops. You came here for a reason, and now you've been here for a while. What's changed What were your impressions coming in? What are your impressions as you're getting ready to leave?
That's an interesting question. So I am sympathetic to people who have to do difficult jobs. And there's no doubt that the people in public bodies who are, I mean, I have worked in the public sector before, and I've responded to freedom of information requests. I haven't, gone through the application of the law to what we can release, but I've been the guy digging for the files. So I do understand and sympathize with the impulse from public bodies to want tools to be able to manage their workload. Now, the third-party exclusions, I don't think are protecting the public bodies. That's a separate issue. I have some spicy opinions about that we may or may not get into. So I think what I want to see is that there's a strong understanding of what the rules are. The rules, as they are applied, are consistent with what legislators tell the public that they are, and that the experience of people going through the system is that the public body is living up to to that promise. That's a bit of a grand highfalutin type of response, but my feeling is that we need to narrow the gap between what politicians will say the legislation does, what the public body experiences that to be, and what the public is getting out of that process.
Yeah, and so now we're seeing all these developments with Bill C-4. Of course, FIPA has been spending a great deal of time on that, and also just how political parties in general are trying to skirt a lot of this, right? They're really trying to avoid, I guess, accountability and transparency, and really kind of almost exercising themselves from that sort of process. So, Ryan, from your experience as a student as well as working in FIPA and working on this, could you kind of give us a rundown of your work regarding that and just your general interpretations of where that's coming from and where that's leading?
Mm-hmm. Yeah, so in my previous co-op term, I got to work on the Liberal Parties versus Complainants case. It's a case that originated as a complaint to the BC Office of Information Privacy Commissioner, has since gone to the courts. The complainants argued that BC's FIPPA legislation applies to political parties. So they are, due to the wording of the private sector access and privacy law, political parties are included in that definition. Now, it's already been established that provincial political parties are covered. This case is determining whether federal political parties are also covered. In and amongst that process, when I first came to it, there had already been some revisions to the Canada Elections Act seeking to exclude political parties from BC's legislation. The court didn't buy it. The case continued through the courts, and the BC Supreme Court found at that stage that the commissioner was right, that BC's law applies to federal political parties. They are an organization of some kind. It applies, no argument. So in the time between that term and this one, I wrote my major paper for advanced legal research and writing on this topic, and bringing in some political theory into how the incentives work to protect political parties from privacy and access, from that kind of supervision that every other organization, we often say, like Tim Hortons is subject to more scrutiny than political parties are. There are, various political theories about how political parties should be understood. In Canada, they're unincorporated associations. The courts don't really like to constrain what unincorporated associations are, what they're subject to. They are considered purely voluntary, a bunch of citizens getting together and doing something on their own power. There's another view of it that they're more like public utilities, and that they should be regulated like public utilities because they facilitate the democratic process. Canada has leaned towards the laissez-faire approach. There are some cases demonstrating that if anybody's interested, they can email me and I can tell you more about that. So I argued in that paper that the court should be braver about applying accountability and applying these types of laws to political parties. Bill C-4 would explicitly overwrite any possibility of using that avenue to apply accountability to them. So part of the changes in Bill C-4 would explicitly exclude federal political parties from any provincial regulation. And it would apply all of the changes retroactively to, I believe, the year 2000, Jason.
Yep.
Effectively rewriting history on this legislation. And there has not been such a brazen attempt to explicitly exclude themselves from accountability. Now, there's some political philosophy stuff about, well, MPs are representing their constituents and they're not acting as part of their political party, so we can't say the political parties are doing this. But I think the party system in Canada is pretty observable. And I think it's difficult to make that case that we shouldn't at least be concerned that political parties are acting in the person of the MP to advance their own interests. Go ahead.
No, I think I'm just curious because, like, this became a huge red flag and something that FIPA we've been talking about, and we've been encouraging listeners every episode at the end, like, and in the show notes, like, we really want you to make your voices heard, that this is not okay. The precedent this sets is really disturbing.
And the interesting thing,
I mean,
if I may, and C-4 is not a privacy or access bill. It's not an elections bill. It is related to affordability. And part of what is so galling about this, to me at least, is that this isn't even, there's not even a fig leaf as to how this relates to affordability. And if it's part of an overall amendment of the Elections Act, okay. If it's related to if it stands on its own in public debate, that's one thing. But to import it into a bill that's related to something of great national importance without highlighting and putting this section up to scrutiny, it doesn't feel like transparency. I can say that.
Well, and the other comparison we like making when we're talking about this bill quite frequently is that you have more access to your personal information held by CSIS than you do from federal political parties. And your spy agency is held to a greater standard of account. Your national spy agency is held to a greater standard of account than your local MP in terms of how his political party handles your personal information. There's a bit of a breakdown in terms of where democracy is being served there, I think. And that's deeply concerning. And, the big takeaway for me in the research that you've been doing and that Gage has done and that others have been doing in this space at FIPA has highlighted to me is this dynamic where we recognize that members of parliament need to be able to communicate with their constituents and they require information to do that. And there is in civil society this requirement to have a two-way flow of information and communications and a civil discourse. But that doesn't mean that I give up my right to my personal information in doing that. And that's a significant shift in this regard. And the political parties seem to want to double down in a way that when I look at and I consider my privacy training, I'm looking at influences in Europe from where privacy was rooted, right? And Germany's background with the Stasi and the reasons why privacy is seen as a fundamental right in guarding against authoritarian states in order to enable democracy, and to create a black hole in C-4 that allows them carte blanche to do whatever they want with your personal information and then not be subject to independent oversight.
And there are constraints on what information they can do, what they can do with the information that they get from Elections Canada. And that's pretty basic information, but there are barely any restrictions currently, and there will be effectively none if C-4 is passed as is, on what they can do with information that they collect otherwise and who they can send it to, how they can disclose it, and who they can pay to do what with it.
So it's been fascinating to see how all that research has unpacked over the last number of years with you and Gage. And I really look forward to continuing that and being able to highlight that with Patrick in the work on the podcast.
I can tell that I'm going to be annoying people at dinner parties with this type of information for a long time. And, as I get into the practice of law, it's something I'm going to be making sure that most of my colleagues are aware of. at least in the rudimentary sense that federal political parties are effectively not held to any kind of privacy or access oversight.
Well, I'll just say, Ryan, I think as a final thing, I mean, is this your last year with FIPPA? Is that right?
Yeah, I mean, I'm not gonna lose Jason's phone number or anything, but this is very likely my last co-op with FIPPA.
Okay.
The relationship's going to continue one way or another. I can already tell.
Okay. Great.
But it is definitely an issue that I'm going to be keeping an eye on in the future.
Yeah, I guess I'm just curious because we've been just referencing your fact that you're a student. Just kind of curious, like where you are in your education and what comes next for you. Just I think that you've been working with us for so long.
Yeah, I'm going to be starting third year in about 3 weeks, and then I have the spring term. I'm going to be in classes, and then depending on how my summer shapes up, I'm either going to be done in the fall or I'm going to be done at the end of 2026. So now I'm starting to think about lining up an articling position. I am open to taking calls on that. If anybody listening has an articling program that they think my experience might suit, and I'm looking forward to seeing where that takes me.
Well, Ryan, we're really grateful for the work that you've done, and thank you for going over the details. Jason, did you have anything else you wanted to ask or add to this?
No, I mean it's the theme at the end of the year. Much thanks and much gratitude to everything that's been occurring over the past year. It's been awesome to work with you, Ryan, and we're really appreciative of the work that you've done to help advance our understanding in this space. And I think you've contributed a fair bit in that regard. And I'm really excited to see where this career takes you as you move forward with it as well, and hope that we've been able to contribute something to your experience that's been meaningful and impactful and helped you set you up for success, because that's ultimately what we aim for in all of these co-op placements. Hopefully we've made an impact. That's the main thing.
Thank you. No, it's been great, and in other circumstances you probably have trouble getting rid of me, but that's the nice thing about co-op is you get to try out new things, and I feel a lot of loyalty towards FIPPA, and that's not just because I happen to agree with the mandate.
All right. Well, Ryan, thank you so much for coming on the podcast again.
Thank you.
And we look forward to whatever you work on in the future with us, and I'm sure you'll come back again. I'm sure we'll do this again.
You know where to find me
in some form or another.
Yeah. Thank you.
Yeah. Okay. Thank
Bye.
you. Access and Privacy Online reviews the headlines and delivers deeper commentary on a regular basis. Be sure to subscribe to get the full episodes every week and get notifications when we release show segments and other commentary throughout the week. We look forward to hearing from you soon. Have a good one.